Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola law firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're going to be discussing real estate broker agreements, and attorneys can also earn CLE credit by listening to this program, and I'll give you the details later in the show, and also the very important code. My guest is Andrew M. Leib. He's a managing attorney at Leib at Law and very prominent real estate attorney here on Long Island and in New York City. He's also very involved in trading real estate brokers, so he's the perfect attorney to guide us through real estate broker agreements. Also assisting me today is Brandon Kaufman. He's a student here at Nassau Community College and involved with the radio station WHPC. So we're ready for our first question from Brandon.
Okay. What is a listing agreement?
Brandon, that's a very good question, particularly because I was listening to the intro to the show, and it was saying law you should know about your home. And I'm thinking to myself, you know what? If you want to protect yourself about your home, you should know about a listing agreement. We're on the same page here. I'll tell you why. Did you realize that this agreement that you're just signing is saying I'm going to owe the broker money if they sell my house? And what's such problematic, I think this is why Ken and myself think this is such an important topic to talk about, is if you're selling your house for $1 million and you're giving a 6% commission, you just made a $60,000 contract, which is just a form. We mentioned the word form contract before, but there's a lot that goes into this listing agreement, this form to sell a home.
And it's going to obligate you to pay a lot of money under certain circumstances. It's important that consumers, real estate attorneys, and the real estate brokers understand when that fee is earned.
Those triggers to commission are huge, and I'll tell you the default rule in the state of New York, if there is no commission, is this ambiguity, which is called, is there a meeting of the mind on substantially all of the essential terms of the transaction? The good thing about this agreement is generally you can change the default rule by this agreement by saying, I only owe the money if my house closes. We see that quite often.
And there are lawsuits, unfortunately, over when a broker has earned fees all the time, and by a properly worded agreement, though hopefully those lawsuits can be avoided, because no one profits from litigation, of course, maybe lawyers.
Well, I was laughing a little while you said that because I profit from that litigation as I'm one of the people that do it. But fortunately, I also do compliance counsel for real estate brokerage companies, and they really don't want this friction. Forgetting the unprofitability, it creates a sour taste in the consumer who we would rather refer the broker into the future. So solving that ambiguity is huge.
And it helps give us certainty to all parties and clarity as well. So let's go back to Brandon for another question.
What are the different types of listing agreements?
So there's three main types of listing agreements, Brandon, although each of these types can have subsets that vary in great deal. The three types are, the first one's called an exclusive right to sell agreement. The second one's called an exclusive agency. The third type is called an open listing. When we talk about an exclusive right to sell, Brandon, what we're saying is, what are the triggers to commission? An exclusive right to sell means if my brokerage firm found the buyer, the brokerage firm earned their commission. If another brokerage firm found the buyer, my brokerage firm still earned the commission.
And there may be a lawsuit by another broker if they somehow sold it.
There could be a lawsuit from another broker, and I think what you're getting at, Ken, is that you can end up owing two commissions in that situation.
Exactly, absolutely. So,
and interestingly enough, if you go to the real estate license law, just Google real estate license law, on the bottom is something called the Glossary of Real Estate Terms, and it's promulgated by the Department of State. It actually says in the definition of exclusive right to sell and exclusive agency, you can end up owing two commissions. So you're right on.
And that's another reason we want everyone to learn from this show and be clear on these terms.
So to go back, the exclusive right to sell has three triggers to commission. The first one is if the brokerage firm I found that I'm using, that I hired, finds a buyer, I owe them money. If another brokerage firm that I might have hired separately or spoke to separately, the one that has this agreement, still earn their money. If I find my buyer on my own, I owe that brokerage firm money.
Right. So these are things the consumer may want to avoid or not. So they want to understand what they're signing and what rights they may be giving away. Because once they sign any of these agreements, they're locked into it, at least for the period of time. So how long do these listing agreements usually in force?
Well, let's start off with that they can't perpetually renew. There's actually a regulation in the brokerage law that says you can't perpetually renew a listing. And they have a time period that they have. Some are 3 months, some are 6 months, some are a year. But I want to backtrack to something you said when you were just saying it, that maybe they want to, maybe they don't want to. Why would a consumer, this is a good question I have, is why would a consumer want to be locked into this exclusive right to sell? I'll tell you the answer. The brokerage firm isn't going to want to invest in advertising your property unless they're guaranteed the money. So if you want their advertising budget, that's why they want the exclusive right to sell.
At the same time, if you end up selling it to a relative of your neighbor, or perhaps a friend who you did not know was interested in your property, as a consumer, you may feel this is crazy. I have to give them tens of thousands of dollars, and I did all the work.
So you know what that consumer should have done? They should have said, do you have an exclusive agency? That's the second type of listing we said.
Okay, and just explain that briefly.
Absolutely. Unlike an exclusive right to sell, if the seller finds their own buyer, they don't owe the commission. So they would only owe a commission if their brokerage company or another brokerage company found the buyer.
And again, they might work out some compromise with a broker where a broker would get a reduced fee for starting the work on the process or evaluating it, let's say 1%. So this keeps them a little bit happy, but the consumer would not end up giving them a windfall.
Correct. Brandon, what do you want to ask?
Sorry if I misunderstand, but owe the commission to who?
Owe the commission to the brokerage firm. So what happens is you might hire an individual salesperson, but the company itself is called a brokerage firm, and they're the people that are owed the commission.
They're like from an office. So most brokers are affiliated with a licensed broker who has, let's say, a store, and it's the office that's a party to this agreement.
Correct. In New York State, there's 3 different license categories. There's real estate salesperson, associate real estate broker, and real estate broker. And only the broker can really have the contract with the seller, whereas the associate real estate broker and salesperson work under the broker. And that's what we're getting at.
But an associate broker is a fully licensed broker, but they don't own their own business?
That's correct. They chose to associate with a real estate brokerage, and then they're treated as a salesperson under the license law.
And the contract is compiled by the broker or more than one?
What do you mean?
Well, usually the listing agreement is a pre-printed form.
Correct.
And it's offered by the broker to the consumer when they want to sell their house. But your question is very good, because the question for Andrew is are the terms of this negotiable?
Yes, but it depends how much leverage you have, just like every other negotiation. What I mean by that is if you're trying to sell a $10 million house in Kings Point, you have a lot more ability to convince the brokerage firm to renegotiate it, as opposed to doing a Hicksville house for $400.
And also depends, how much they do budget and spend money on advertising and how much time they spend on it. A broker might have an incentive to spend more time marketing houses where they have an exclusive because they're going to get the full commission.
100%, and that goes to my point of how much the value is, because a broker gets a percentage as their commission, so they're going to have much more ability to market a property that's worth a lot more money.
And just going back to types of agreements, you've told us about the exclusive right to sell. You've told us about the agency, exclusive agent, where the seller themselves, the consumer, reserves their right to sell without paying a commission. And just tell us about the open listing.
I think that's the one you're going to like the most. An open listing means I, the consumer, am free to give as many brokerage firms I want a listing of my property, and I only have to pay the first one who delivers me a buyer.
Now, is it so you're giving each a number of more than one broker an exclusive?
Well, no, it's not an exclusive. You're giving one or more than one brokerage firm a listing agreement where they can go find a buyer. The disadvantage of an open is they're not going to want to advertise it, because any other brokerage firm could come directly to me and say, if you give me a commission, I have a buyer for you.
So you're giving different brokers an exclusive?
Not an exclusive. You're giving different brokers a listing.
Okay. But if they sell, they're going to
They get paid.
But you might reserve a right for yourself to sell it.
Open listing by nature reserves a right for you yourself to sell it or any other brokerage.
Okay, and these listing agreements, do they apply to rentals?
So that's a very good question. Just like in sales, you can have an agreement for rentals because what is the listing agreement about? It's about, as Ken asked before, the time period that you're going to give a broker an opportunity and what the triggers to commission are.
And you mentioned before that we know there's something out there called the multiple listing service, and sometimes brokers share information among other brokers. What is it called in that situation?
That's called a co-broke, and I want to tell you how great of a segue that is if we go back to the open listing.
Yes.
Because if you were a broker and I gave you an open listing agreement, why on earth would you advertise on the multiple listing service and allow other brokers to know about it? Because those brokers wouldn't have to co-broke with you or work with you. They could cut you out and go around you right to me, the seller.
So this cuts you in for a piece of action because you signed the listing.
What cuts you in for a piece of action? I lost you. Does the open listing cut you in for a piece of action? Yes, the open listing cuts you in for an action, but the only properties that you're going to have two different brokerage companies cooperating on, called a co-broke, is if you have an exclusive right to sell or an exclusive agency, because otherwise on an open listing, the selling side, the person who brings the buyer, can go around the listing brokerage and just go directly to the seller and get a higher commission.
Right, so that's once it's the initial broker might then share the listing on the multiple listing service.
100% if it's the exclusive right to sell, 100% if it's an exclusive agency. They would never, ever do it on the open listing, because if they do on the open listing, they're inviting their competitors to cut them out and go around them.
Right.
And that's the big reason why you'd give the exclusive right to sell to go from the beginning, because the multiple listing service is a boom to get market share, to let people know that your property's out there. How else are you going to market the property? Right now, you mentioned MLS. Did you know there's a public on Long Island, not just Stratus MLS, the LIBOR site, the Long Island Board of Realtors site, but there's just MLSLI. Any consumer can just go on MLSLI.com and see all the properties. But no broker is going to put it on there if they don't have an exclusive.
And I guess consumers also go on a place like Zillow or other sites that are consumer-friendly.
Correct.
To research houses for sale. So a broker is only going to put the house there if they know they're going to
get a commission. Because if you're not going to get a commission, so open listings I want you to think about more like a pocket listing. It's something that's in-house to the brokerage firm where they're whispering it. People call it a whisper listing. But they're not going to go promote it or advertise it because they'd be advertising themselves out of a commission.
And they're going to seek a commission if they played some role in procuring the buyer, even if there's no formal written contract. If somehow they showed it to a person and that person ended up buying the property, they're going to seek a commission.
Well, I want to simplify that sentence because there's a lot to it. The first one is, does there have to be a written agreement? The answer is absolutely not. In the state of New York, a real estate broker is an exception to the statute of frauds. It's expressly stated at subsection 10 in the general obligation law. You'll see it. I think it's 5-70110, but I could be wrong. And it's an express exception for a brokerage agreement. And the default rule on the exception to the statute of frauds, meaning that agreements have to be in writing and brokers don't have to, is the trigger to commission is a meeting of the minds of substantially all of the essential terms of the transaction. And that segues to your second part of the question. It's not if they just did some part of it. They had to do substantially all of the procurement to be able to be earning a commission. That being said, there's unscrupulous people out there that just introduce someone to a property and they're still looking for commission.
Right, and that's all the more reason it's good to have things in writing so there's no questions for litigation later on.
Always put all your agreements in writing.
Okay, we have to take a short break now. When we return, we'll continue our discussion of real estate broker agreements. And again, attorneys, you may be eligible to earn CLE through this by going through the Nassau Academy of Law, and you can go to nassaubar.org for details on the Nassau Academy of Law and find out about their administrative requirements. You're listening to Law You Should Know on 90.3 WHPC, the voice of Nassau Community College, and also over the internet at ncc.edu/WHPC. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, who wants you to know about ADR, Alternate Dispute Resolution, which can help you avoid costly, lengthy, and uncertain litigation in court. By resolving disputes through mediation or arbitration, it gives you control over who decides your case. A mediator helps all parties to reach an agreement